whether reservations had ceased to exist, or the legal phrases had been disestablished. And it was virtually always, I think always in cases that the court had looked at, as a consequence of allotment. Now, allotment, and this is something you may know about too, was the big federal policy in the late 19th and very early 20th centuries. Somebody in Washington decided that the way to help tribal members advance up the ladder of civilization was to take their collectively owned lands and carve them up into individual farms and ranches, and sort of, get them excited about being property owners and yeoman farmers and, having their own space, and then they'll put more time into it if it's theirs, et cetera. And so they went around the country carving up or allotting reservations. Most reservations, they would allot a fixed acreage per tribal member. And by the way, to figure out who was entitled to an allotment, they would send teams of federal agents out to conduct censuses or rolls of tribal citizens. And you'll know in Oklahoma, for the 5 tribes anyway, these are all famous, the famous Dawes rolls, because Henry Dawes headed the commission that came out to take list of people who were entitled for allotment. And this is what citizenship in most, if not all, these tribes is based on today, descent from somebody on a Dawes roll. But they were doing censuses all over the country. And then if the deal for that particular tribe was a fixed number of acres, and it was commonly an 80-acre farm or a 160-acre ranch, you'd pick it, everybody got one per capita, the baby got one, grandma got one, dad got one, mom got one. And then there'd probably be land left over, and they called that the surplus lands, and that would either be bought by the US or sold by the US acting as a real estate agent to non-Indians who wanted to come in to buy it. Muskogee Creek cut a deal where the entirety of the reservation would be allotted, so there wouldn't be any non-Indians moving in, at least initially. The feds put in a place of process for a fixed period of time, and that eventually got extended to be indefinite. The lands could not be sold by the allottee, but Congress created something called the competency process, where they would send agents out, and if they determined that you were competent to manage your own land, then they would remove the restriction on sale, and then that would open it up for non-Indians to come in and buy it. And that, of course, is what happened to most of the lands in the Muskogee Creek Reservation. They became the southern 2/3 of the city of Tulsa and loads of other counties with non-Indians buying lands from allottees and moving in after the restrictions on sale were removed. And it was done person by person. Well, in some cases, as I mentioned, when all that happened, the court was prepared to find that reservation doesn't exist anymore. But before they would find that, the test was, we're going to look at the allotment statute to see if there's anything in there that says expressly your reservation is disestablished. If there isn't, if it's ambiguous maybe, then we'll look at the legislative history, we'll look at surrounding circumstances, and we'll look at subsequent demography. So like, did a whole lot of non-Indians move in? And if the answer to that question, or maybe some combination of those questions, was yeah, there looks like they thought this was going to be state land and not Indian country anymore. The state started exercising jurisdiction over it almost immediately, et cetera. Then the court sometimes would find that reservation was disestablished. And that means that it's not Indian country anymore. And if that's what they found for Muskogee Creek, then McGirt's staying in prison. And as Michael mentioned, I think the assumption was, among most people, certainly the state's assumption was that all of the reservations in Oklahoma had been disestablished through allotment or at the time of statehood or some other event that happened in the late 18th or early 19th century. And so they were all state lands. Well, when McGirt got to the court, the Supreme Court looked at it and said, I don't think that's how we're going to decide this. We're not going to do what the state wants us to do and look at a lot of the surrounding circumstances and subsequent demography. The state made arguments like, look how many non-Indians live in Tulsa. How can this possibly be subject to Muskogee Creek jurisdiction? And the court said, well, you know, what we have to do, and this is Justice Gorsuch's view, he's a textualist, he's an originalist. Justice Gorsuch said, what difference does it make what happened in the 100 and some years after the allotment of the Muskogee Creek Reservation? All that matters is what the Allotment Act says. And we don't even really care what the legislative history says if the Allotment Act does not clearly disestablish this reservation, or maybe at least contains some language that suggests disestablishment, creating ambiguity, then we're going to find it's not disestablished, and the consequences are whatever they are. It's not our job to, you know, make life easier and bend the law a little bit. Our job is to enforce whatever deal Congress made back at the time that Muskogee Creek Nation lands were allotted. And so he looked at the statute, said there's nothing in this thing that says disestablishment. This looks just like they were carving it up and the tribal members were going to share it to have the opportunity to learn how to become, you know, proud property owners of individual farms and ranches. But the reservation, as far as we can tell, was going to continue to exist. The tribal government was expressly empowered to continue to exist. And there's nothing in here that's ambiguous. He also said clearly, we're not going to allow subsequent events to create an ambiguity in the text where no ambiguity actually exists in the text. And so, you know, that's the rule, and this is the rule. The decision that the majority of the court, it was a 5-4 decision, reached in the McGirt case, Muskogee Creek Nation was not disestablished at the time of allotment, and that means it is still Indian country, all of that green area over my shoulder, for purposes at least of the Major Crimes Act, and one assumes the Indian Country Crimes Act. And that means McGirt was not subject to state jurisdiction for the crime that he committed. Now, let's get rid of poor Mr. McGirt. He won. He, you know, became a part of the history of federal Indian law, was removed from state prison, almost immediately re-prosecuted by the U.S. Attorney for the Northern District of Oklahoma, another former student of mine, found guilty, and last I checked was awaiting sentencing. So he was just sort of changing rooms, moving from a state prison to a federal prison, possibly still for the rest of his life. But his claim has made a big difference for initially Muskogee Creek Nation on the criminal front, because what it meant, going back to that the statutes I talked about a while ago, is within that green area, which is the newly re-recognized Muskogee Creek Reservation, which is to say it's all Indian country for federal Indian law purposes. From now on, if you are an Indian who commits a crime in that area, it doesn't matter what the crime is, you are not subject to state jurisdiction. If you are a non-Indian who commits a crime against an Indian, by the way, is the term used in the US Criminal Code, which is why I'm using it, you are not subject to state jurisdiction. In the former case, Indian defendant, you're subject to federal and tribal jurisdiction. In the latter case, you're only subject to federal jurisdiction. The only criminal defendant subject to state jurisdiction anymore in that area are non-Indians who commit crimes against other non-Indians. And they're going to be subject to exclusive state jurisdiction. It also means that if you're a police officer in those counties, I think it's 11, all or part of 11 counties, you are checking tribal citizenship anytime a crime is committed. You know you're in Indian country, so that's not an open question anymore. And if you've got an Indian defendant, you're also checking the nature of the crime, because if it's a major crime, then the feds have jurisdiction regardless of who the victim is. The tribe will have concurrent jurisdiction as well. The party entity most heavily impacted by this was the US Attorney's Office. because initially, because they suddenly had jurisdiction to re-prosecute any state felon who had committed a crime that was now determined to be subject not to state jurisdiction, but to federal jurisdiction. And going forward, any felonies they were going to prosecute. Ultimately, however, I think the entity that's going to bear the heaviest burden here is the tribe, because they have exclusive jurisdiction over all minor crimes, misdemeanors committed by Indians against Indians, and doesn't matter which tribe, and effectively exclusive jurisdiction over misdemeanors committed by Indians against non-Indians, because while the feds could prosecute those under the Indian Country Crimes Act, because they're misdemeanors, they usually won't, right? They only have so many prosecutors. The FBI only has so many agents to do investigations, and so they tend to focus on major crimes, right, on felonies and not on misdemeanors. Big hiring going on. The U.S. Attorney's Office for the northern and eastern districts of Oklahoma, bringing in U.S. attorneys from all over the United States, hiring new lawyers. Muskogee Creek Nation hiring lawyers, new prosecutors, new investigators because of their enhanced jurisdiction. The state district attorneys, I thought this was sort of weird. They actually filed an amicus brief arguing, you know, the state has jurisdiction here. And I found myself, I mean, I understand why, but I found part of myself thinking, why would you do? I mean, this is like you could just suddenly doubled your amount of vacation time because you've lost jurisdiction. You're handing responsibility over to the feds for so many of these cases. You can go to the beach, you can hang out, spend more time with your kids. Why would you fight for retention? But in any event, I do understand it. I said that was a little bit facetious. It's the principle. So that was Muskogee Creek. In the interest of time, let me fast forward, and then I want to take questions. Muskogee Creek wasn't the end of the road for McGirt because, as I mentioned, the material analysis for the majority was, well, what did their allotment act say? And there are five, it used to be called 5 civilized tribes. Now we call them the 5 nations, most commonly in eastern Oklahoma, that all got removed here from the Southeast in the 1830s and 40s. And they're all have allotment acts that are virtually identical in material articles. And so people thought, even at the time that McGirt was being argued, this is not just going to be Muskogee Creek, this is going to be Cherokee and Choctaw and Chickasaw and Seminole as well. And so unsurprisingly, as soon as McGirt came down, those cases started getting put together. And since McGirt, we have had 2 decisions from the Oklahoma Court of Criminal Appeals regarding 2 of those reservations, in both of which the court found that they were intact too and had not been disestablished. This is going, maybe looking into the future. One is the Cherokee Nation, and the other is the Chickasaw Nation. So that's the orange and the purple, I guess that's purple. Both of those are now officially Indian country under Section 1151A, at least again for criminal jurisdiction purposes. We have pending cases, I believe, and I'm sure we do, involving Choctaw, and I think involving Seminole as well. And so we'll have to wait and see what the court says there, but the expectation is that those tribes reservations will be re-recognized too, which means that all of that colored area in the eastern half of Oklahoma, probably within the next 6 to 8 months, will be recognized as Indian country. What does this mean for the state? Well, again, a massive shift in criminal jurisdiction. What does it mean for me? Probably a massive increase in enrollment in Indian law courses, which is fine. I love having lots of students. And we'll see what happens with the other tribes. The Peoria had a case that state trial court criminal prosecution trial judge said the same applied to, that their reservation had not been disestablished. That's the only other decision we've gotten. But as I say, there are other tribes that have pending cases. It's not the tribes, by the way, bringing the cases. It's criminal defendants who are citizens of those tribes saying, hey, my reservation too is still intact. And so we shouldn't, we weren't subject to state jurisdiction. By the way, I'll say one more thing, and then if you'll let me, permit me to, before turning this over, and this is really a serious thing, to Q&A. I don't, are there any lawyers in here, active practicing lawyers in here? Okay, Dick, you don't practice, do you practice? In addition to,
no, not
well,
anymore. Not anymore.
well, you might
No.
be interested in this anyway. Michael
Okay.
does. So we set up, and we did this partly because of McGirt, although it sort of exploded after McGirt. If you are a lawyer in any area where the lands are have been found to be Indian country again, I don't think you can practice law without knowing the Indian law rules on criminal jurisdiction. And if this rolls into civil jurisdiction, you won't even know who's supposed to pay income tax where. So we started a few years ago at the law school an online, concentrated, comprehensive, here's everything you need to know about Indian law program for tribal leaders. It's as a master's program. And we've had hundreds of students from around the country in the master's program. But last year, we added an LLM option for practicing lawyers, and that program has exploded too, with lawyers mainly from Muskogee Creek at this point, who think it's a 15-month program, it's all online, and it's asynchronous, which I didn't know what that word meant before, but means that they're recorded videos, so you watch them at your convenience. Everybody in the program has a full-time job. And we have, I think, the most comprehensive Indian law curriculum in the country. And we actually expanded it for purposes of this program. So every course you take covers gaming and economic development and sacred sites and jurisdiction, the criminal side and civil side, and that sort of thing. So if you are, or if you know anybody who's a lawyer who wants in real short order to get an LLM in Indigenous Peoples Law so that they can do all this stuff, have them contact me or contact the law school, and we'd be more than happy to talk to them about how the program works. And that's all I'm going to say. With the time that's left, I'm happy to take any questions.
I've got a question. Professor Robertson, thanks very much. This is terrific and fascinating. And I'm not practicing law anymore, but once a lawyer, always a lawyer. We think that way. My question concerns the extent to which this will carry over into civil law. I know taxation, the Muskogee Creek Nation is already involved in that, who can collect taxes, et cetera. How far do you see that going? Thank you.
Yeah, it's hard to say. I think the expectation, even if the McGirt argument was that it would roll into the civil side, a lot of the dissent's position was driven by anxiety over how the state would cope with the civil consequences of McGirt. So there's a lot of discussion about compacts, and tribes and state in Oklahoma have a long history of working this stuff out. I think initially the state, I think, thought, this will probably cover civil too, because there's only one definition of Indian country. It happens to be in the criminal volume, but there isn't any like a civil definition that's different somewhere in the US code. But the states decided to take the official position that McGirt only applies to criminal jurisdiction and maybe only applies to the Major Crimes Act, because that's all that was issue in McGirt. And I think what that means is we're going to have litigation on that to figure out whether McGirt does apply. I think the state is prepared, at least understands, has been investigating and understands how this would work on the civil side, in particular on taxation. And and I've been sort of involved in that, but there's loads of tax law on how taxation jurisdiction is allocated in Indian country, and it's complex, but not incomprehensible. They're fairly clear rules, but we could do a whole breakfast on that, Dick. Civil jurisdiction in Indian country.
Sure.
I guess I'm going to refrain from venturing an opinion, although I do have one. But we'll see. All I can say is there is nothing. there is nothing in the McGirt majority that says this only applies on the criminal side. But it is true that it was a criminal case that didn't raise issues of civil jurisdiction. In order for there to be a different result, the court would have to decide, and they haven't decided this, I believe, to this point, that there's a different definition for Indian country on the civil side than on the criminal side. And that would, so they would have to be willing to make that leap in order to find that this didn't apply on the civil side. But I expect we know, because you're right, people have been raising this on the tax front already. I think this is one we'll have an answer to within the next 12 months.
And where would that answer come from? Is there a particular case you're looking at?
Well, there's several, and I don't know. I really don't know. I think there's Muskogee Creek. I think there was about to be a Seminole case that got withdrawn. Some people, on the tax side, this is sort of interesting too, and I didn't realize this until recently, but in the federal system, you actually have to pay the tax before you can challenge its legality. In Oklahoma, you don't. So you can just say, I'm not paying, and then we've all got to wait, which makes it easier to challenge. You might get stuck with penalties, but it's cheaper to challenge the lawfulness of a state tax than a federal tax. So I'd be surprised if we didn't see more cases coming. So we'll see. Great question.
Thanks a lot.
Professor, we had a question in the chat for you from Sandra Longprior, asking if you think SCOTUS got it right in this case, and then what other important questions in Indian law that you would like to see reviewed by the judiciary. And then lastly, does this case provide an indication of how the court could rule on those questions?
Yeah, so that's a great question. And I had a really committed answer right up until Justice Ginsburg died. And the challenge now is, we don't know what the court's going to do, because Justice Ginsburg, who was in the majority, was replaced by Justice Barrett, who might vote with the other side, but we don't have any idea what she thinks about Indian law cases. She's also a textualist like Justice Gorsuch, so this is sort of a non-political decision. I think, so did they get it right? I kind of think that they did. I think they did, but what's interesting is they actually got it right in the sense that I'm sympathetic to textualism and originalism, and so it is a more consistent, with that notion. But it's also completely consistent with a decision they issued recently called Nebraska versus Parker, which was unanimous and said the same thing. So this wasn't entirely novel. That involved a little town in Nebraska. Tulsa's much bigger, but that was really the only operative difference between those cases. So their decision is consistent with their own case law. And why should it? I mean, I think the court itself had recognized in previous cases that it doesn't really make sense to interpret congressional intent at the time of the passage of an early 20th century statute by looking to who lives there today, right? Subsequent demography as evidence of intent, it is suspect. And they said that in the case where they announced the test that I briefly discussed a little bit earlier. So I actually think it was a fair decision. I think it's a consequential decision. I think it was a brave decision in a sense for justice, and it's a very eloquent opinion. I encourage you to read it too. It's got the memorable line at the end of the Trail of Tears was a promise. And basically the promise was we'd leave you people alone, and we didn't. And now we're going to make up for it by re-recognizing your reservation.
Michael?
Yeah, real quickly. I live in Far East Norman, and the property to my east and to my west, both directions, is Indian country. So I've been interested in Indian law for many, many years. It's relevant to all of us who live in Norman, even if we're not aware of it. The foundation for Indian law can be traced back to the 1820s and 1830s. The three cases that were issued by Chief Justice Marshall, they're known as the Marshall Trilogy. And the first of those three, Johnson versus McIntosh, was a corrupt, collusive setup, basically. And there's a great book out there that if anyone's interested in the history, without wanting to get bogged down in the legalese, but if you're interested in the history of the story of the foundation of American Indian law, which provides the basis really for indigenous people's law around the world, there's a book called Conquest by Law that's written by Professor Lindsay Robertson. Pick it up. You can pick it up on Amazon.
Michael, I'm taking you with me everywhere from now on. Thank you for the plug.
And then we had another, I guess, question in the chat, Professor, asking if you were familiar with the Curtis Act arguments that municipalities continue to have jurisdiction over all persons within the city limits.
I'm familiar with the fact that there are such arguments, and I know the Curtis Act, and I've read the Curtis Act. I don't have an opinion about where they're going to go, those arguments, although I'm suspicious. I'm not optimistic that that's going to overturn stuff, but I don't know. I haven't really engaged with anybody in the argument, so it would be unfair for me to express an opinion, but I am familiar with them.
Professor, good to see you again. I have a question, actually, without getting too far in the weeds. I wanted to know if you've been following the U.S. versus Cooley arguments lately, and if you have an opinion on any of that.
Yeah, I listened to the oral argument. Cooley is a case involving, and this is why everybody should have cross-deputization agreements. What happens if a tribal police officer, this is non-Oklahoma, it's in, Northern Plains somewhere, I don't remember where. And what happens if a non-Indian is pulled by a tribal police officer and held for a period of time while the cop looks through his car and finds incriminating evidence, and there are questions about admissibility of evidence, given that the tribal police officer, under the statutes that I talked about, has no jurisdiction over the non-Indian. And I don't know it's a great question, Aaron, and I don't know what's going to happen with that case. I just don't know. It's possible. I guess if I had to guess, I'd guess that the non-Indian is going to win, but I don't really know, given that the intrusion was sort of de minimis, arguably, but then you either have jurisdiction or you don't. So that one I do not know. I am, though, when I have talked with people at Cooley, it's simply to encourage the adoption of cross-deputization agreements, because then the case would never have gone anywhere. If he didn't have jurisdiction as a tribal police officer, he did as a state police officer. So, problem solved, and evidence goes in, and we're done.
Well, we're kind of a little bit past our 8 o'clock hour, but Professor Robertson, thank you for being here this morning with us. I think when we start meeting back in person, we'd love to have you join us for breakfast one morning and to further the discussion. So thank you everyone for attending this morning and for the great interaction and questions. I think that's it. So go out and have a great week and be the difference in your community. Thank you again.
Thank you, Jane. Thanks to all of you for spending time with me and inviting me this morning. I really appreciate it.
Thanks very much.
Thank you.